Conversations in Civics. I'm Dr. Terri Susan Fine. With me is Jan Leisher. Jan teaches gifted social studies at Bridgewater Middle School in Winter Garden, and Jan also serves as a civics mentor teacher with the Florida Joint Center for Citizenship. Today we're going to be talking about civil liberties, something that's central to the American way of life.
Thank you, Terri. Is it true that Americans have this idea of civil liberties that, I don't know, is it always historical? Do we always think about civil liberties in the way that the constitutional framers might have intended?
You know, it's a great question to start off our conversation, because the civil liberties that we know are embodied mostly in the Bill of Rights, although they've been extended through the 14th Amendment and citizenship in the states and those kinds of things and what the state needs to do. But if we look at the Bill of Rights, what we'll find is that there are a lot of protections and freedoms that are protected in a single sentence. So, yes, 200 plus years ago, we have embodied in the Constitution freedom of speech, freedom of press, freedom of assembly. We live in the internet age. We live in a high-tech age. So how do we translate those constitutional hallmarks and those rights into the 21st century? And that's why it's both a historical and a contemporary document.
I think that tells me a lot about understanding how it was then and how it is today. Mm-hmm. Well, one thing that students always have a confusion about is this freedom of expression. Mm-hmm. That's what teenagers say, freedom of expression. Constitutionally, how can we explain that to them?
That's a great question, because freedom of expression is found nowhere in the U.S. Constitution. It simply isn't there. However, the United States Supreme Court is the ultimate interpreter of what the Constitution means, including the Bill of Rights. Mm-hmm. So what we have had, particularly in the 20th century and on into the 21st century, is that the United States Supreme Court has taken the words of the Bill of Rights and interpreted them to mean expression. At the same time, let's be clear, another group of people on the Supreme Court, or a change in the Supreme Court, can always change the way those same words are interpreted. So we talk about freedom of expression not only because it's been interpreted from the specific freedoms identified, say in the First Amendment, speech, press, assembly, etc., but in addition to that, there are ways that people have utilized the First Amendment consistent with what the writers of the First Amendment thought in modern ways. So, for example, we sometimes think of the Supreme Court case dealing with whether or not a person could wear an item of clothing in a certain way that expressed their political views. Well, it's not speech, it's not assembly, it's not press. So the First Amendment doesn't say you can wear an armband to school or you can't wear an armband to school. But at the same time, if the First Amendment was meant to protect political views without being punished for expressing them, then we see on a case-by-case basis the Supreme Court has interpreted the specific rights in these very contemporary ways.
That sounds a lot like the Tinker case.
Yes.
And of course, I think students also have to sometimes be led to understand that history plays a tremendous part in how the Supreme Court might react to a situation, and what might be something the Supreme Court would say in the 60s, the Supreme Court in the 21st century might say something entirely different.
You're so right, because in the early 20th century there was a Supreme Court case, I think it was around 1904, 1905, and there was what we call a famous footnote in the case. And the famous footnote included a statement like, freedom of speech does not mean that you can yell fire in a crowded movie theater. It does not extend to that. And the reason is not because literally if you scream something else in a movie theater or you scream fire someplace else, then it's okay. What it means is that when your expression in some way compromises the public interest, then the government can regulate that expression. The Supreme Court has found that if expression does not compromise or in some way damage or hurt or make vulnerable the public interest, then people's rights of expression are further enhanced. So we often call that a balancing test. If you look at it as a seesaw, right? That when the nation is under some kind of attack, when the nation is being threatened, then the public interest weight side of the seesaw, then that's focused. But if everything's at peace, everyone's at peace and there's no problems, then maybe people are allowed to say things and do things that are okay. So we find that during peacetime, that individual rights tend to be weighted on the seesaw, but during wartime, then public interest tends to be weighted on that seesaw. It's a balancing test.
I'm reminded also of the Patriot Act and things that the legislature might do that impact people's civil liberties, and then of course how the Supreme Court may react to those given the times.
You've raised two very important points in that very short sentence. Patriot Act, it was enacted in 2002. We have to ask ourselves, would there have been a Patriot Act unless the nation as a whole had been threatened in a significant way due to the consequences of September 11th, 2001? Of course not. And that's the government reacting in a way to protect the public interest. What you also said was, if the Supreme Court should react. The Supreme Court does not evaluate every piece of public policy. The public, through its attorneys and through other institutions and organizations, brings cases before the Supreme Court, and the Supreme Court has to decide, is there a constitutional question that needs to be addressed here? Is there a possibility that there's a state law that is violating somebody's civil liberties? And did you know, Jan, that the Supreme Court only accepts 1% of all the cases that it is asked to rule on? Did you know that?
That's amazing.
So when we hear these phrases, I'm going to take my case to the Supreme Court, well, you can try all you want, but 99 times out of 100, you're not going to succeed. Yeah.
Well, civil liberties, when I'm teaching to students, obviously the Patriot Act, they don't see a whole lot of that as being applicable to them.
Right.
But we do talk about travel, and we do talk about when you go into an airport. And we talk about, you know, it being a balancing, just as you said, sometimes you have to give up a little bit of your civil liberties in order to, you know, be protected or to be safe. And so for them, you know, traveling on airplanes is a real vivid example of how this balancing act plays out in their lives.
Well, one of those very short sentences in the Bill of Rights is the Fourth Amendment, and it says that you are protected from unreasonable searches and seizures. However, what is also included in that Fourth Amendment is something called probable cause. And what has happened, particularly since 9/11 and since the Patriot Act, is a lot of legislation that essentially says, look, simply by deciding to go on an airplane and to pack certain things in your luggage or to carry certain things on your person or to have had certain kinds of conversations with people or interactions with people, we might have some probable cause that 10 years before 9/11, somebody would say, that's not probable cause, but probable cause can be interpreted to mean different things, not only by different people, but under different circumstances. The Fifth Amendment also says that you must have due process before your life or your freedom, life or liberty, is taken from you. That's called the Due Process Clause. And some people say, well, if you're saying that I have to go through all these things just to fly in a plane, you're denying me my due process because, according to the Fourth Amendment, you don't have probable cause. And the federal government's response is that this is a privilege. It is a privilege to fly on a plane. It's not a right that we have to guarantee. It's a privilege. And in order to enjoy that privilege, we have to protect the society while at the same time giving you the privilege of air travel.
That's a good way to look at the difference between privileges and rights. Can you think of some other examples of civil liberties today that are debatable in our modern context that maybe the framers had not anticipated?
Absolutely. When we sometimes think about the Fourth, Fifth, and Sixth Amendments, we look at those, many people say, as the rights of criminals. No one is a criminal unless they've been convicted of a crime. The Fourth Amendment, which protects you from unreasonable search and seizure, Fifth Amendment due process, Sixth Amendment right to counsel, those are protections of people who've been accused of crimes. And we get very hot under the collar about whether or not someone who killed someone else should be given due process. But they are still citizens. They are still citizens of the United States. The one that's really debatable now is the Eighth Amendment. The Eighth Amendment says that you shall be protected from cruel and unusual punishment. The words death and penalty come no place together in the Constitution, and yet the death penalty has been looked at and evaluated through the Eighth Amendment. And so what the Supreme Court has done, particularly in the 1970s, which is when sort of the most important death penalty cases sort of came to their attention and they agreed to hear them, right? Were cases that ultimately resulted in sort of two areas of protection of citizens. And we are dealing with citizens. We need to remember that. First of all was the punishment itself cannot be cruel or unusual, which means that when the death penalty is administered, it must be quick and painless. Okay? So, for example, you can't drown someone. Okay? You can electrocute them. You can put them in a gas chamber. There are other methods that you can use. A lethal injection is becoming the most popular because it's the easiest to regulate. Mm-hmm. At the same time, what the Supreme Court has dealt with is who gets the death penalty. There were some studies done by a professor whose last name is Baldus. So you might have heard of the Baldus studies. And the Baldus studies essentially asked the question, are people given the punishment of death more often minority races than white? And what Baldus found was that particularly if the person who was accused of the crime was African American and his victim was white, then he was 4 times more likely to get the death penalty than in the reverse situation, which would be if the victim were African American and the perpetrator were white. So what we find is in the 1970s and really going into the early 1980s that there were just a series of cases surrounding what makes the death penalty neither cruel nor unusual nor racist in its administration. And that's sort of where we stand today. There was a case out of Kentucky a couple of years ago, and that was called Bays versus Reese. And in that case, the issue was in lethal injection, which is becoming more and more popular. In lethal injection, if the 3 shots that someone is given, right, for the lethal injection, if the first one, it paralyzes them, and the second one is supposed to take away pain and it doesn't, then what happens when their heart stops with the third one and they feel themselves dying and there's no way for them to express that? But the Supreme Court did not side with the defendant in this one, in that the Supreme Court found that cruel and unusual punishment was not being administered with the lethal injection. So in terms of debatability, all of them are debatable, but there's a lot of attention paid to either new ways of political expression, issues pertaining to the rights of the accused and how well those rights are administered. Mm-hmm. So for example, if your attorney doesn't represent you well, if you're using the public defender, does that mean that you have been denied your right to counsel, right? Gideon versus Wainwright dealt with the issue. If you can't pay for an attorney, have you been denied your right to counsel? The Supreme Court said, yes, you have, okay? And then we also find in terms of the Eighth Amendment, the debatability is surrounding whether or not something is cruel and unusual in its administration or cruel and unusual in terms of deciding who is to receive the death penalty versus some other kind of punishment, such as life in prison without parole. Jan, thank you so much for joining me today. It's been a terrific conversation. Just to recap quickly, we've been talking about civil liberties, the origin of the concept and how we address civil liberties today and how civil liberties are addressed in the Constitution. And that's Conversations in Civics. I'm Dr. Terri Susan Fine.